the truth is, I can't imagine, really, I can't imagine how you could design a worse system for dealing with sexual harassment than forced arbitration. I mean, it's just the worst possible regime. First, the entire regime is shrouded in secrecy. And not just because victims want to keep these issues confidential, which, by the way, is up to them, right? They should have the autonomy and the choice to decide. But because companies want to keep this stuff under wraps. They want to hide and shield sexual predators, and they don't want their business in the public eye. They don't want to deal with regulators or even with lawsuits. The secrecy here on its own just makes this a terrible way to deal with sexual harassment, because it means that victims of sexual violence in the workplace who bravely try to come forward are prohibited from telling their stories in a public forum. Instead, they're forced into this private process where everything is under wraps and siloed, right? So this is the second bad thing. Victims can't join together, even when their injuries stem from the same wrongdoing, even when they've occurred at the hands of the same perpetrator, even when the company's tolerance for sexual harassment is structural and pervasive. Victims have to go it alone, never knowing about one another. They have to go into arbitration single file. I don't know where all these statistics are coming from about how great arbitration is, how people win it all the time, because the truth is, no one goes into arbitration because it's siloed, because it's secret, because they don't know about what else is going on in the workplace. The secrecy that blankets these individualized proceedings prevents one victim from ever learning whether others right in the cubicle next to them might have experienced the same tragedies, the same traumas. And when survivors are in the dark about cases filed by others in the workplace, that makes coming forward, that makes being the first person to come forward that much harder. As a corollary, and this is an important corollary, the relief that is available to the individual claimant doesn't prevent the wrongdoer from preying on other women, doesn't prevent the predator from having all sorts of misconduct against other women in the workplace. The proceedings are one-on-one, and the relief that arbitrators are allowed by contract to grant is individualized. They can't ever order any changes beyond what can help this one individual that happens to have the courage to come before them. I mean, can you imagine a worse system for dealing with toxic corporate culture? Because I can't. Third, and I think this is really important, and all the survivors have spoken about this, forced arbitration is a system where the employers write the rules and they pick the arbitral provider, which means that victims of sexual harassment are shunted into a regime that's stacked against them from the get-go. First, because the arbitrator's economic interest is to be very good to the repeat player employer so that they can be chosen for another arbitration next time. So the repeat player problem has been well documented, and I think it's alive and well in arbitration, and the secrecy protects that. And second, because the employer designs the entire arbitration process, it does so to serve its interests, not the interests of its workers, but its interests, which again are to keep discrimination and harassment under a veil of secrecy and out of the public eye. So given all of these things, given how bad this system is for victims of sexual harassment, it's no wonder that so few ever decide to go into private arbitration. I wouldn't. I think it sounds terrible. Because the truth is that, you know, we can't reform this system as Ranking Member Jordan I think expressed in his opening that maybe this is a system that can be fixed. I challenge you to really find a way to do that, because it's broken and it doesn't work. And moreover, none of the victims want it, right? So you can't fix it if it doesn't work. And I don't think it works. These victims deserve the right to decide for themselves where and how to file a case. They deserve to be free from retaliation for complaining about the treatment that they've suffered in the workplace. They deserve to tell their stories and to have us hear their stories, to have you hear their stories, and to hold perpetrators and employers accountable for pervasive misconduct. None of this is possible in a system of forced arbitration.
Professor Gillis, with the time I have left, could you highlight the breadth of forced arbitration's impact on sexual assault and harassment cases?
Yeah, of course. So, it starts at the very beginning. A woman, a victim of sexual harassment, tries to complain about her treatment, and she doesn't get anywhere with HR, so she tries to file a lawsuit, but as Ms. Henry indicated earlier, and I think her story is a story of so many women in this situation, she learns only upon speaking to a lawyer, reviewing documents, that she signed something somewhere that she doesn't even remember. None of us remember all those documents they give us to sign on orientation day. And in there, tucked in the very deep, deep fine print, is a forced arbitration clause that says that you've waived your right to a jury. You have to go into a private arbitration pre-designated by the employer, who's retained that arbitration provider, so you're not very sure how fair the proceeding will actually be. In arbitration, for this apparent speed and cheapness, we get very, very streamlined proceedings, so streamlined that the rules of discovery and the rules of evidence and other procedural protections that would apply in court no longer apply. And so right off the bat, we're just treating these people as though they're second-class citizens. When an arbitration complaint is filed, it's filed in secret. In other words, the only entities that know that the arbitration has even been filed are the employer, the complaining employee, and the arbitration entity, the AAA or JAMS or one of these arbitration providers. Nobody else knows. Contrast that with court. If I go down to the DC District Court today and I file a complaint, that complaint is on the public record, right? And so is the defendant's answer or motion to dismiss. All the pleadings, they're public. Litigation in the public court system, it has power, and the power it has is the power of signaling, not only to the defendant that I've sued, but to all similarly situated defendants, that this is a wrong. This person has complained about something, she's told her story, and she plans to prove it. None of that happens in arbitration. From the beginning, it is private throughout the entire proceeding, which is held in a secret location, no public, no press. All of it is private. Arbitrators don't write decisions. There are only 3 states in the union that currently require minimal disclosure of arbitrations. Pretty redacted and hard to read if you're a researcher like I am about these issues. Other than that, everything that happens in arbitration is a black box. And so should we be surprised that women are feeling incredibly angry that they don't get to tell their story, that they don't get to know whether the place they choose to work is full of problems that they never learn about? This is overwhelmingly bad, right? This is, as I said in my opening remarks, I think the worst possible system one could design to deal with a problem of this nature.